My name is Shubhang Ignatius Francis, and we'll be discussing labor laws in India. Before we jump into the topic, we'll first discuss the jurisprudence behind it. Here are the few listed jurisprudential terms which will help us to understand why labor laws came into India. First, rise of industrialization. Second, labor exploitation. Third, social justice concerns. Fourth, legislative intervention. Fifth, judicial proceedings. Sixth, economic changes. Rise of industrialization. This is the basis of why and how labor laws came into India. We'll be discussing that in detail, but these are few industrialization jurisprudence which you can read into and which will help you to understand why there was a need of labor laws in India. The seventh point is social movements, like labor movements and advocacy for workers, rights, influence, legal reforms, and the creation of industrial jurisprudence. And also, we can see there was a global trend, like there were international developments in labor rights and industrial relations, which was influenced by Indians, and India took these global labor rights as the basis of the policies. Ninth, emergence of collective bargaining. One of the bases for labor law is to actually support collective bargaining and negotiation as alternatives to unilateral employer decisions. The 10th point is role of industrial tribunals. Establishment of tribunals is to address the dispute and shape new contractual agreements between the parties. The 11th point is recognition of status over contract. It means that the transition from contractual relationships between the employer and the employee, then to recognizing the socio-economic status of the workers and reflecting change in societal norms. The 12th point is inclusion of labor in management. 13th, protection of worker rights. We all know the main basis for labor laws to come into India was to protect the rights of the workers. 14th, overall socio-economic progress. The basis to understand the problems and the jurisprudence behind the industry is to recognize the socio-economic condition of the workers and shape the laws and the policies according to it. Now we will be dealing with the principles of industrial jurisprudence. There are 7 principles listed below on the PPT for you guys. Now, the first principle states that the right of workmen to combine and form associations or unions. The basis of jurisprudential aspect is the workers should have a right to combine and form associations to collectively bargain their problems for a better condition of services, which is also the second point of the principles. And the third is the realization that economic struggle is inevitable because it is but neutral that labor would agitate for better conditions. There are certain principles these workers have is to raise the concern collectively so that they should have a socio-economic or proper conditions for them to live in. The fourth principle is a shift from doctrine of laissez-faire to a welfare state. The fifth point is tripartite consultations, that is the solution of industrial or labor disputes through participation of workers, employees, and the government. The fifth point is very crucial, which employs 3 levels of understanding, like there should be government, employees, and workers involved in solution and decision making when a policy or a law is being made. The sixth point is also very important. The government should no more be a neutral onlooker but must interfere as the protector of social good. This is also the fourth principle, as well as it states that the government should not leave just ignore the rights of the workers, but it should interfere so that the workers are not violated of their rights. The seventh, minimum standards must be guaranteed through state legislations. The state should come up with certain legislation so that certain minimum standards these workers have a right. It should not be they should not be deprived of these rights. They should at least be given the minimum standard that a human is required. Now we would be discussing how labor policy in India came about. After independence, it was largely felt that the labor policy must emphasize upon self reliance on the part of workers since independence till 1954. The period when V.V. Giri was the labor minister, all official pronouncements emphasized that labor should become self reliant. An equally forceful view had been to prefer reliance upon the government. This cross current of approach to the labor policy gave place to a new approach known as tripartism, as we also discussed the principles behind labor jurisprudence. Now, thus, tripartism became the central theme in the so called Nanda period that began in 1957. During this period, the government paid reliance on three-party approach, namely the trade union representing the workers, the employers, and the government. Now, in in this now in this kind of approach, the representative do not decide anything, but their role is mainly advisory. They meet together, discuss the points in dispute, and strive to reach to a consensus. And if they agree, they make recommendations. Now, one out of three, the role of government is very important. Now, annual labor conferences at the permanent standing labor committees served as the chief instrument of tripartism. These conferences advocated, amongst many things, workers' participation in the legislation. Now we can see that at the 16th century, 16th conference held in 1958, a momentous advancement was made by adopting a code of discipline in industry. The code pledged that the parties to avoid strikes and lockouts without any notice, and to and to issue unilateral actions and to rely on settlement of disputes by discussion by voluntary arbitration. Now they emphasize more on the both the parties, like in an industry where workers and the employer, they are they work together and they have a contractual relations, and if there is a dispute between them, they should come together and discuss it rather than strikes and lockouts. The labor policy has proceeded on a realization that the community as a whole, as well as individual, secure to them their due share in the gains of economic development. Now this has led to enacting of Payment of Bonus Act. Now this act aimed at providing for the payment of bonus on the basis of profit or on the basis of production or productivity. Now, the main postulates of labor policy may be summed as follows. First, recognition of state as custodian of interest of community as the catalyst of change and welfare programs. Second, recognition of the right of workers to peaceful direct action if justice is denied to them. Third, encouragement to mutual settlement, collective bargaining, and voluntary arbitration. Fourth, intervention by the state in favor of the weaker party to ensure this is very important, to ensure fair treatment to all concerned. Fifth, primacy to maintenance of industrial peace. Sixth, evolving partnership between the employer and employees in a constructive endeavor to promote the satisfaction of the economic needs of the community in the best possible manner. Seventh, ensuring fair wages, standard and provisions of social security. Eighth, cooperation for augmenting production and increasing productivity. Ninth, adequate enforcement of legislation. This is very important. Now, tenth, enhancing the status of the worker in the industry. 11, tripartite consultation. Now we will be moving on to understand the industrial relations and why they are very important in an industry. An industry is a social world in miniature. Industries help in production and provide employment to the people of society. Different categories of human elements are involved in an industry. The relations of these groups enters part in an part in the establishment and maintenance of industrial democracy. This is very important. The economic activity is the central field of industrial relations. The economic system of any nation affects the industrial nation relations, which in turn affects the social order. Now, for example, a man has to struggle with his environment for earning his bread and satisfaction of his material wants. Now, industrial relations are nothing more than create an imbalance in the society as they prejudicially affect the rights and interest of those sections who work in such industries but do not control it. It results in inequitable distribution of wealth because the relations in between the workers and the employees is not proper. They have a dispute between them because means of production are controlled by the dominant section of society who exploit the labor to their own maximum benefit. Now if the relations between the worker and the employee is not proper, so the production and the economic outcome of that work will not be up to the mark. Also, it is because of these far reaching consequences of the imbalance and disorder in industrial relations, and because the fact that it affects such a large and varied complex of group relationship, that it was soon realized that very existence of the state. Now state should play a very important role as a protector of the country and as arbitrator of conflicting interests between the workers and the employer. Now, economic progress is also bound up with industrial peace, which I've already mentioned before. Now, industrial relations are therefore not a matter between employers and employees alone. You should emphasize on that. But it is a concern of the community which may be expressed in measures for the protection of its larger interest. Now, the next point is state intervention. State intervention is also justified to prevent exploitation of the weaker section of the society by the stronger section. Industry owners are not the only party to be blamed for the industrial disorder, but the state, whose duty is to establish a just social order, is equally to be blamed. Social justice requires that the state, for its own existence, owes an obligation to the community to bridge the gap between the two classes and evolve a healthy social order. It is therefore this fountain of social justice that the necessity of legal regulation by the state of industrial relations has flown. The scope of governmental legal regulation of industrial relations depend upon the social economic objective that the state seeks to attain, and these would be reflected in the socio-economic planning and the labor policies by the nation. Now, it is further conditioned by the degree of the existing social imbalance which needs social readjustment and the conceived picture of ideas which feed the program of social justice in the given socio-economic situation. Now, we in our country are mainly embracing upon the industrial and technological advancement, but not only technical advancement will widen the social imbalance, advancement of knowledge of social science is necessary for reshaping the social relationship. Therefore, a state must endeavor and promote the studies and researches in the sciences which will help in reshaping social relationships. Now, it is the state's duty to actually focus on maintaining these relationships so that these industrial relationships in the industries between the employer and the employee is not widening up. After understanding the principles of industrial jurisprudence, we should now understand why there was such a need for understanding the industrial jurisprudence in the first place. It all began with industrialization in India. There was a revolution in India that happened, and as in any other country, it implies as in any other country, it implies the growth of a factory system with employers and wage earners in varying circumstances and with the varying characteristics, yet having some common features, and it is the common features that are of interest. Now, as a consequences of introduction of factory system, producing became concentrated in a few selected places, resulting in the increase of labor population in all such places. The village workers migrated to industrial towns because of the difficulty of finding adequate livelihood in their native place. Now, this resulted in disappearance of the popular village handicraft systems because they could not compete with the machines made good. It implies that the basic things which these villages were famous for, the handicraft and the local products, it all, they could not compete with the modern industrializations, as the modern industrialization came up with advanced machinery which overtook their job. Now, the good produced on a mass scale with the help of machines in the industries were cheaper than the good produced by handcraft methods, as already mentioned. Now, but the development of an industry in India brought with with it a great evil. Because of these great evil that was brought, these craftsmen, these workers, local workers, they had to migrate from village to industrial cities in search of employment in a factory. Now, there are certain evils of an industry which can be classified into two broad characteristics, that is, economic and social evil. We will now be discussing what economic evil means. The artisan who first traveled to city after his job was overtaken by the heavy machineries had the psychological satisfaction of a producing of the goods himself in the factory system, only a tender of the machine. He had to produce the good with the help of tools which he had the pleasure of making that particular handicraft with his own hand. Now, he had to produce the good with the help of tools in the factory. Now, in the factory system of producing, only a part of goods were produced by a certain categories of workers. Now, different categories of workers produce different composite labor and of many categories of workers. The workman in this system did not get full psychological satisfaction of manufacturing product by himself, and this indirectly arrested his mental development and creative talents of the local talented handicraft workmen were completely destroyed. Second, these workers who came from villages to the factories, the wages paid to the factory workers were quite inadequate to meet their various needs in the new environment, which was different from the rural life. Also, the employment of factory workers was not secure in the beginning. They had to suffer occasionally from periodic unemployment and underemployment. As a consequence of overproduction of trade cycles, a worker could be discharged from his employer anytime without assigning any reasons. This also gave rise to social evils. These factories were sick not only of economic evil but also social evil. Overcrowded cities with insanitary slums, acute housing shortage because of large scale migration of village population. Now, workers in factory, they had no safety gears with them. They were just made to work without any safety measures, They were exposed to serious accidents because of the lack of negligence on the part of the employer. And also mentioned they were paid very low wages, which could not even meet their basic minimum standards. Now, the issue of labor problems poses a significant threat to society, necessitating immediate action and resolutions. Employers have historically prioritized machinery maintenance and technical advancement over welfare of the laborers, who often lack awareness of the right due to illiteracy and poverty. This means that these workers, they came to the city just to work, and they were not even aware of the basic rights minimum standards issued by the government to them. This this fact of illiteracy was taken as a measure by these employers, who took advantage of the illiteracy of the workers to exploit them. However, the worsening situation eventually compelled government intervention to address industrial conflicts. As we already discussed in the postulates, it mentioned that the government intervention should be there in order to protect the workers from being getting exploited. Not only that, after seeing the workers getting exploited, post independence there were certain NGOs, PILs being filed in the court, actions being taken against these industrial worker or employers, so that these workers should not be exploited of the right, and basic minimum standard should be guaranteed to them. Now, in order for industry to work, is that already discussed the industrial relations in an industry and what it actually means. It actually helps in promoting the economic the benefit for the employer, as well as a condition for an employee to work with a peace. Now we'll discuss certain terms like in what industrial peace and industrial harmony means in an industry. While industrial peace, it primarily focuses on elimination of discord. On the other hand, industrial harmony embodies a more positive and comprehensive notion. It signifies the existence of mutual understanding, and this cooperation and sense of a partnership between employers and employees to pursue an industrial harmony is essential for the economic progress of a nation. Both industrial harmony and peace are integral to economic advancement. Industrial harmony fosters increased cooperation between the employers and employees, leading to an enhanced productivity. Now, if the workers are happy and the employees are happy, if they work together and avoid disputes between them, and the conditions in an industry is with industrial harmony and everyone is working with the peace of mind, we can always see an in economic advancement, as well as a environment where both workers and employers, they work as one, not as a boss and a servant. This relationship can be removed only if industrial harmony and peace is maintained in the society. Thank you, guys.